Good afternoon. Quick share here, something that occurred here yesterday, and I'm just fulfilling an obligation with regard to it. I wanted to share with you because it can help potentially you if this happens to you. Sometimes you have a hearing scheduled that you're going to be attending, and most of them are by MS Teams today in current era. And you get a call that it has to be adjourned. You get a call from the hearing office. Now, in this case, what happened was, this is a very complicated case, but there was supposed to be some reports from SSA doctors in the file that the judge was waiting on to have this third hearing on the same case. So this has been a really convoluted case, taking a lot of time, probably not the least of which was related initially to COVID. And now, of course, maybe short staff. But anyway, some SSA exams took place. The reports were not in the file leading up to the hearing. And I was checking the electronic file every day because the visits were only January 6th and the hearing was January 18th. So I kept checking. And when it wasn't there on the 17th, I contacted the hearings office and spoke to the judge's clerk, who looked into it and communicated, I guess, with the judge, to be told that no, the hearing can't go forward without those. So unfortunately, the hearing had to be adjourned, and I was really not looking forward to telling my client because he's been very patient and very frustrated, and he's in a really difficult spot. So as unpleasant as it is, my point here is that normally there's a 75-day notice requirement to schedule a new hearing. That is a benefit to the claimant. It's not the benefit to the SSA or the hearings office. It is to make sure that he has plenty of time to make arrangements to be at the hearing and or to get all those final pieces of evidence in. The most updated evidence is what you want for any hearing. Ideally, it would be up to the date of hearing, although that's almost impossible. But you certainly need notice. And also for both, whether there's an attorney or not, for the claimant to be available on that day. He could be away. He could have a really important doctor's visit, what have you. So you can waive, as a claimant, you can waive the 75-day notice. You can, there is a form, it's called the HA, I would think it would be a -510. One pager, you just say you're waiving the 75-day notice, you sign it, and they don't have to comply with it. Doesn't mean you're going to get it tomorrow or in 2 weeks, but at least it means the OHO does not have to force it to wait 75 days because you're waiving that time. In this case, I spoke to my client, and I thought that would be definitely a smart thing to do, since our case is totally ready, and I'm sure by then those medical reports from these very, sorry to say, remiss medical providers that are on contract with the SSA to do these kind of consultative examinations when a judge wants them. They're usually done earlier, such as on initial or reconsideration, and they were in this case, but then this delay that's been taking place made it wise for another exam. So you can waive it. You want to get that HA 510 and shoot it up to your judge's office, the Office of Hearings Operations, and at least then they won't be forced to make you wait even longer, okay? Because that's not really, they don't have a right to waive it for you. That is your right. Your right to the 75 or your right to waive the 75. So anyway, hope that helps somebody. And if you have any questions, you know where to reach me. Bye now.